So you have a quasi-judicial hearing, a due process hearing coming up in your district. What's the first thing that has to happen? Well, somebody's got to be assigned, in my mind, to take responsibility for this process. And that doesn't mean substantive responsibility for managing the decision. That's up to you as members of the board in the end. But somebody has to think about how we're going to get through the process, and usually that will be your administrator, superintendent, or principal. But it needs to occur, and if you don't have that, if you don't have a routine, a practice in place for doing that, you probably ought to attend to it. Obviously, an important planning question that comes up is, what are you going to do about counsel, legal counsel? I think few school boards in Vermont would be so brave, some would say so foolish, as to proceed through an employee termination case without involving legal counsel. Mm-hmm. I suppose some do. I don't obviously get to see that.
Or sometimes you do when it goes foul.
Well, I can imagine that I might. I haven't had that occasion yet, which leads me to think almost all boards are involving counsel in a hearing of that level of significance. If you're going to have counsel, the next question becomes, well, how many lawyers are you going to have, and what are their roles going to be? And if the district is in a position where it can afford to do it the right way, I think it's pretty clear what the right thing to do is. And that is to separate out the role of, in effect, prosecutor from the role of advisor to the board. So that many districts that I've been involved with have had exactly that situation. The board has its own attorney. Some of them, I've seen situations where a chair really sort of delegated authority to run the hearing to the board's attorney, and I think you're legally allowed to do that, although I think it's preferable if you can not to do that, to have your board chair preside. And then have this separate attorney who actually represents the administration that's going to carry the burden of proof in your case. And I speak in those terms because this is really a trial-like proceeding. And if nobody has sat down in advance and said what facts have to be presented to the board in order for the board to go ahead and do what it is the administration wants done here, then you're not very likely to have a successful hearing. So whether or not your administration is represented separately by counsel, somebody needs to think that one through. Mm-hmm. And I guess that's the real point of the slide, is it takes a little substantive planning to do this right.
So it's potentially likely you could have 3 attorneys in a hearing.
You could, yes, and I've even seen more.
Okay.
Because sometimes with union employees, the union will have counsel there present to represent the employee, and I've seen situations in which the employee had their own counsel present as well, although I wouldn't allow, if I were presiding over such a hearing, I wouldn't allow both lawyers to function independently in the case. They'd have to
caucus.
They'd have to work it out between them.
Okay.
Forgive me if I missed this, but there's a bullet, the second bullet, legal advice in advance only.
Well, I'm glad you asked the question, because that was laid out because I have seen boards that wanted to proceed that way, and I think that's sort of the minimum involvement that you have to have. The statutes don't say that a board must be represented by counsel. They don't say that an administration must be represented by counsel. Most will do so. Some boards, in an effort to save some money, are only going to have some advice about how to proceed. And I think that would be a very difficult situation, but I have seen boards try to do that, although very few will do that when a lawyer shows up on behalf of the individual who's engaged in the process.
Okay. Good question. Thanks, Ken.
In a really simple case, we've had some students. The other thing that obviously has to be done up front in terms of thinking about how to proceed with the case is that some practical issues have to be dealt with. How many people are going to be at this meeting, and what do we need to do in terms of organizing the room in a way that will work so that the meeting can proceed efficiently and effectively. Some particular recurring problems occur. Where will witnesses sit in relation to the board and to the parties? What, if anything, are we going to do about privacy issues if this is a hearing that's conducted in executive sessions? And many of these hearings, I would say a majority of these hearings, are conducted in private, in executive session, because private rights on the part of an employee or a student who's involved are at issue, and the statutes that relate to that permit them to go forward privately. So if that's the case, how are you going to arrange to have this be a private room? If you have some sort of mix, and the question that was asked earlier about student records really relates to that, and I've seen this come up, how are you going to arrange things in such a way that some things can be done privately and some things in public session? If there are going to be people there, someone's got to arrange for microphones. If they're going to be, and I've seen and participated in some quasi-judicial hearings where there were a lot of people present and they were done publicly. How are we going to manage this crowd and allow them to feel attended to and to feel that they've had their proper role, if there is a proper role for them in this setting?
So the defendant here could choose to have this be public, and the board would have to go along with that?
If we're talking about a teacher termination case, the statute's quite clear that the teacher can waive the right to have this done in executive session and have it be done publicly.
Why would a teacher choose to do it that way?
Well, I participated in a case where that was the situation, and it was a case in which the teacher had lots of support in the community, and she wanted the board to know that. And in fact, 100 people came and sat through 17 hours of school board hearing that I participated in some time ago. It was truly a trial in both senses of the word.
Oh dear.
Obviously, someone has to warn the meeting, as would happen with any of our meetings, and comply with the public notice requirements of the statute, and somebody from the administration is going to have to give the board at least a heads up that this is happening, if not getting into the merits, as they shouldn't.